Good morning. Good morning. You can go join on Telegram, and I'm gonna send the link in Telegram. I just started. We're not gonna. I'm not gonna really. I'm just having TikTok open for people, but what we're gonna be doing is we're gonna be having our live discussion on. We're gonna have. I'm gonna send a Zoom link into my Telegram channel. You guys can join from Telegram. All right. If you don't have Telegram, get Telegram. You're missing out. I'm telling you, Telegram is it's a big deal. All right, so let's do that. But what I'm gonna do, I'm dropping the. We are live now. Okay, so anyone can join if you go to my Telegram channel. All right, and click the Zoom link that I just dropped in there. You're gonna be on live on YouTube with me and whoever else decides to show up. All right. So first thing is, what do you guys want to talk about today? What do you want to talk about? Okay. I've gotten. It was funny because a few years ago, everything was about passports, right? It was all about changing the passport, updating the passport. Now it doesn't seem to be that today. It seems more like what we're getting into today is other things. Everyone's trying to do this like, the Admiralty Act. Okay. Um, well, that's a good question. What could we do about the Admiralty Act? But hey, um, so let's take a look here. But yeah, everyone was involved in that. Everyone's talking about hospital. Uh, anyway, the thing was that now everyone's talking about like the 1040 ESs and stuff like that, and I'm going to tell you flat out, it is not that is not a process that I would do, and I'll tell you the reason why I won't do it. The reason why I won't do it is because it's not correct. Okay, the IRS is going to come back and tell people, "Where's your payment?" Right? And I know you're trying to turn the ESs into like a payment, but that process isn't working. So it's not going to be done that way. It's just not. It's not correct. Okay, it's not a correct process. Plus, and here's the additional thing: when you start talking about if you're using the Social Security number for a process, guess what? That's called private. It's a private process. You shouldn't be sharing that publicly. What happens is when you share these private processes publicly, they get shut down. Right? They stop working. The W4 sandwich is a perfect example of that. That was a process that was being done privately, right, in these private groups like Telegram and stuff, and it was fine. What happened is that once it was shared publicly, like put on YouTube or something like that, then it got shut down. Okay, and those are the things you got to watch out for. There's a lot of process we could talk about publicly, like the passport. Okay, um, I'm not going to get into these other things. By the way, if you want to join my Telegram. Go to the Zoom link that I just put in Telegram, and from there, join in and have a conversation with me on YouTube, on Zoom. I'll be on Zoom, but I'm not going to add anyone to TikTok, all right? So if you're trying to join on TikTok, come back over and join on Telegram. Go to my link tree in my bio. There's Telegram, The Freedom Fighters, and then you can click the link and you'll be right on here in Zoom with me, all right? So that you can do. Why do you always type in capital letters? I have to ignore that because it becomes a big distraction. Right? Everyone's communication is just as important as everyone else's. Um, okay, I'm gonna close this out. I'm gonna close this. Close that. Uh, wow, this is weird. How come I thought I had to? Oh, here I see what I did. Okay, I'm gonna turn off the waiting room. Just remember, you're live on YouTube now, so everyone's going to be seeing you on YouTube. They're going to see your picture too. Well, whatever. It's up to you. Um, it's gonna happen either way. So let's do. What if we do like a gallery or something? Whatever. I don't know what's going on here. Anyway, maybe if I pin myself, what if I did that? Maybe if I pin, that might work. Anyway, how's it going? You're allowed to talk though.
Oh, sorry, Joe. I figured it out. I figured out how to hide myself. Thank you.
Okay. Yeah, just
I was just tickled to find you this morning. So this is exciting.
yeah.
Are
Yes,
you teaching? Oh, sorry.
we're just live. Whatever. We're talking about whatever you want to talk about. Someone's fighting a foreclosure. You have to fill out an appeal. How to fill out? You have to write a brief. That's how you do appeals. You have to write a brief, which is going to be about like 20 pages. Okay, but what you need to do from the appeal. So what you got to do, you got to go to my Telegram, go click the Zoom link that I just shared, and come on here and talk with us on Zoom because the TikTok is just to get people to move over to here so we can actually have a conversation. All right, because then we'll be on Zoom. But when you're doing this stuff, you have to do when you're doing an appeal, you have to write a brief. Okay, that's how that works. So you have to write a brief, but you're gonna have to, and you got to make a good argument. Okay, you can't. Don't use these stupid arguments that people are using, like I gave them a promissory notice payment. And you ain't gonna get anywhere with that. Okay, you're not gonna get anywhere. If you use federal codes in state court, they're gonna laugh at you about that too. Okay, so there's a lot of trickery going on with the state courts and foreclosures. All right, so just keep that stuff in mind. But you can do the appeal. All right, and then you have to ask the right kind of questions. You have to do good discovery. All right, interrogatories. Okay, get these guys to really like open up. Um, Yeah, yeah, I'm not. Please, please, if you want to talk about this, move over to the Zoom and have a conversation with me on Zoom because I can't keep reading every little thing and then trying to narrate what you're saying to everyone else that's watching. All right, so it would be easier if you just move over. Come here. I'm pinned on here, so they won't see you if that's what you're afraid of. But people who are on the Zoom call, you can freely talk. All right. But come on over and we'll go over that stuff there. All right. So, what do you guys want to talk about over here? You can unmute. This is free for all. You just chit chat. We're talking. This is. I have to always remind people we can just talk freely. What the heck? Got nothing to say?
I'll come up with a question. I'm looking through my notes.
Oh boy. Yeah, Norman, you're speaking dog Latin. You're typing in dog Latin is what you're doing. Um, all right. Hey, how's it going?
Hey, I'm trying to still stop garnishments from my paycheck. I was wondering, I also sent this company a 1099-C and I still haven't heard a response back.
Garnishments, what bullets it for?
Um, Credit cards or credit card.
Did you lose a court case?
Yeah, it was a judgment against me also for it.
Mm, all right. So, all right. Well, that's losing the court case, right? It's the same thing.
Yeah.
S- Right. So, all right. So you got to,
Also
let's,
on the final judgment of that court case, on the bottom date, it has a wrong date instead
doesn't
of
matter.
23. It
No,
doesn't matter.
they'll overlook that. That's like just a little, that's a
All right.
typographical error. They're not, they're going to be like, no, that was just a mistake made by the clerk or by somebody. They'll override
Oh
that.
yeah.
That
Right.
Yeah, I've tried to do that with insurance stuff in the past. They go, well, that's just a mistake, and it's just an error. They human error. People make it, so they'll
Oh
let
yeah.
that stuff. You try to use things like that after them, but if it's something not that important, they'll just, well, it was a mistake.
Right. Right.
So no, what you got to do is you should do an appeal, right, on the credit cards, and then you got to ask like good questions. Like when you did the court case, what did you submit into court? Did you do an interrogatory and give it to the credit card company?
No, I didn't know what I was doing in that court date.
Right.
I didn't do nothing, and then ended up leaving during it to go to the clerk, and I guess they said, "Oh, yep, he wasn't here." So
All right. So that's fine. How long ago was it?
that was in 2023.
I mean, I don't know what state you're on, but you should be able to do an appeal, and then I would do a writ of prohibition to stop the like I would do an appeal, do a writ of prohibition to stop the garnishments and the check temporarily until you go through the appeal case. And in the appeal case, you can make a lot of complaints like, hey, there was no firsthand witnesses, there was no under penalty of perjury on the plaintiff's side, right? From who had firsthand knowledge of the facts.
Right.
And then now they're going to have to go back and look at it and go, yeah, there isn't any of that. You're right. Oh. And they might say, well, you didn't bring it up. But no. That means they didn't have jurisdiction, right? Because who's bringing the complaint? You know?
Right.
And I would go in that direction because firsthand knowledge is very important. Affidavits are very, very important. If they don't have that stuff, then they're going to, everything's hearsay, right? Affidavits is an affidavit, right? It's admissible evidence, right? That's what they used to get warrants. That's your
Yeah.
Fourth Amendment right. Is like if they issue a warrant for somebody, it has to be backed by like an affidavit, right? My Telegram group is in. If you go to my bio, there's a Linktree link, and then the Telegram group is listed in there. All right.
Also with that, I was what did it say before they started garnishing? They said to counter this, I had to respond to the courts by like a certain date, and I did. I ended up paying court a certain date, saying, hey, I was supposed to respond, blah blah blah, and they gave me a little court filing and all this, and then nothing ever came about that.
You just said, oh, okay, I'm gonna fight this, and they just stopped talking to you.
Yeah, it just I did. They said respond to the allegation or something by a certain date. I did, and then filed it with the clerk, paid whatever $135 for the filing, and then I never heard anything back from that.
No.
And then they just started garnishing paycheck. I was like,
Are you in my trust community?
no, I'm not.
Okay. All right. Yeah, there's processes that we do in there. They're private processes I can't talk about on TikTok or YouTube, but there are
Right.
some processes we do that we can fix that, like so that way you can get all your garnishments back. But we can't.
I can message you. I can message you a little later and see if I can get in that with you.
Yeah, but we're gonna go over that inside the community.
Okay.
So it's something we do within there, which works. You know. Yeah, that way you can get all the garnishments back. Which I think would be nice, right?
All right. Yeah, definitely.
Yeah. Plus, we can also do things like you would have to do an appeal right now. You would have to do an appeal, and you'd have to put in things like firsthand knowledge, right? And you have to utilize what you have to do. One thing is that you have to look into what state are you in?
Illinois.
Okay. You can use the UCCs there, but you have to be very cunning about how you bring these things up. Okay.
Right.
8. Okay. Here, I'll show you. So is this it? Yeah, I think I found it. All right, so this is the UCCs in Illinois. It's actually 810 Illinois code or whatever. I don't know what that means, but these are this is the Uniform Commercial Code inside of there. So you would have to cite anytime you cite the UCCs in your state case, you have to use the state UCC code. Okay, if you use like UCC 3, they're going to ignore it. But if you use like the state code, they can't override that. All right. So that's important. Like here.
Well, where'd you find those?
You just go look, just the
Oh, okay. I see. I got you.
yeah.
Yeah.
Illinois' compiled statutes, commercial code.
Right.
And then if you go to here's let's do Article 5, letters of credit, because when you signed the application, okay, you issued them a letter of credit. All right, so it's open-ended credit. That's what credit cards are. They're open-ended debentures, is what they really are. So an applicant means one at whose request or for whose account. What account are they talking about? If you're an applicant, you don't have an account yet, right? Unless it says for whose account a letter of credit is issued. So there's a presumption that there's already an account in existence, right? You see that?
Yeah. Right.
Right? Because when you go apply for a credit card or something, they're assuming you already have an account. So what account is that?
Yeah.
That's our Social Security account. Because what do they want on the application? Social Security number, right? So that's whose account a letter of credit is issued. The term includes a person who requests an issuer to issue a letter of credit on behalf of another if the person making the request undertakes an obligation to reimburse the issuer. Now, this is really interesting because when we go through these UCCs, you find out that the issuer is the maker of an instrument, right? That's the one who signs like the promissory note or the bill of exchange and gives it to the bank to start the loan process, right? So that's what they're doing here, okay? So think about when you're the applicant, that means you actually fund this whole thing, and when you sign the agreement, you become the issuer. So they have to reimburse you. They have to reimburse you. It says it right here. Right? A beneficiary means a person who under the terms of the letter of credit is entitled to have its complying presentation honored. The term includes a person to whom drawing rights have been transferred under a transferable letter of credit. Okay. So it's interesting when we start looking at these things, like what's going on here. So you go from applicant to issuer, right? And then, but they'll always take credit as being the issuer. They'll say, well, we issued that, and they go and submit that onto the SEC, right? On a Form 10 normally, right here, look, Form 10 SEC form. Okay. And this is the form that they put this on. General form for registration of securities. Okay. So they go and take that, they go register the security on here. Securities to be registered, title of class, right? Potential persons who are respond to collection of information contained in this form are not required to respond unless form contains displays a currently valid OMB control number. There's your OMB number. Okay. So this is something that people don't understand. Like I see people sharing like all these forms that don't work or whatever. But yeah. So this is what you're going to, you have this commercial and trade, but we're talking about your UCCs here. And that's the first thing, is asking them, where is the letter of credit? Okay. So where's the letter of credit? Can I get a copy of that the original letter of credit? Who is the issuer? Ask them questions like that. Who is the issuer? Right? The issuer means a bank or other person that issues a letter of credit but does not include an individual who makes an engagement for personal, family, or household purposes. So they say, well, we're the issuer. And you say, oh, okay, you're the issuer. And who's the applicant? Well, you would be the applicant. Okay, and who is the beneficiary? You want to ask them, who are all these people? Okay, you want to get them to tell you who is who. All right, and then we can go down to our, oh, no, not this one. It's under 9. If we go down to 9 and we go look at, we have account, accounting, assigning, consignor, debtor. Debtor means a person having an interest other than a security interest or other lien in the collateral, whether or not the person is an obligor. Okay. And then you have to ask them, well, where in the contract did it say that I agreed to having a garnishment in my pay if I don't pay this alleged debt? Always call it alleged. Okay, it's not a valid debt until it's been proven. Okay, so it's always alleged. Okay, but this is stuff I would put into this appeal. I need to know who's the debtor, who's the issuer, right? Where's the original letter of credit, right? What account did those funds come out of? How much did they loan me? What account did they loan me from? Because the banking laws say this. They're not allowed to make loans, right? Well, it says it right here, 12 U.S. Code 83. Okay, it says no national bank shall make any loan or discount the security of its shares of its own capital stock. So where'd they get this money from? All right, did they get it from the people that giving them money? Because that means that all their clients or customers are now actually the ones that are loaning the money. That sounds illegal, right? Imagine if you gave me like $100 to Joe. Here, I'm gonna give you $100 to hold on for me. I have to go somewhere. Just hold this money for me so I don't lose it. I say, okay, all right. And then let's say Rick comes over here and says, hey, I need to borrow some money. And so, oh, I got this $100. You can borrow that. That wasn't my money to loan, was it? This sounds like what the banks are doing then. So you could get them in a really interesting situation here, right? Now, when you talk about these U.S. codes, they'll laugh at you about the U.S. codes. Okay, so you always have to call them by the stat number. See this statute right here? That's the number you got to use because that's admissible. That's admissible in court. The U.S. code is not admissible in court. Okay, so and I'll show you. It's come on. Statutes at large, contents, admissibility, and evidence. Okay, it says the United States statutes at large shall be legal evidence of laws, concurrent resolutions, treaties, international agreements other than treaties, proclamations by the President, and proposed or ratified amendments to the Constitution of the United States therein contained in all the courts of the United States, the several states, and the territories and insular possessions of the United States. So this is why when people go, oh, I submitted this stuff in and it has all these U.S. codes on there, they go, oh, that's federal law. You see, like all the TikTok attorneys go and start saying, oh, that's federal law. That doesn't apply in the state. That doesn't apply in the state. And I go, okay, they're right. But the statutes at large do. They tell you right here. So when you go into a state court, you got to use the statutes at large. This is why all the bonds that I write work, because I don't use codes. I don't use any of the U.S. codes or the UCCs. This is why when I do the coupons, they work, because I don't use the UCCs or any of the codes. I don't do any of that stuff. All right. I always use the statutes at large. And I use the actual way it's written, not the modified version in the U.S. codes, because the U.S. codes are modified unless it's positive law. All right. I'll show you that. Let's go U.S. Yeah, we'll go here. So look, if you look at these titles, okay, you see how like this has an asterisk and this doesn't? You guys see that? So the asterisk here, I'm going to show you what that is. This title has been enacted as positive law. However, any appendix to this title has not been enacted as part of the title. So what they're telling you is that this is positive law, which means that positive law is unaltered. Okay? It's exactly the same as it was in the statutes at large. Now look, let's go to 26. Oh, are you shocked? Title 26 is not positive law. But Title 1 is. Title 1 is positive law. Title 4 is positive law. Right? Congress is not. How do you like that? Isn't that interesting? I get a kick out of this stuff. Title 2 is not positive law. Title 5 is, and we have a lot of stuff in there. See the appendix? The appendix is not considered positive law. Banking is not positive law. That's because they do all these modifications. They do all these modifications and they only apply in certain situations. Right? That's the other thing people have to realize. Right? Like Title 50. It's not positive law. Okay, that's why when we use like the Trading with the Enemy Act, you have to use the statute at large. You can't use the U.S. Code. Transportation Title 49 is positive law. This is why all 50 states have an exemption for driving versus traveling. Although, the states are in complete rebellion on your right to travel because it's going to cut $1 billion industry out of their state if they grant everyone the right to travel. So they're not going to do it. All right, that's the problem. But we've come up with ways to get it to work. It does work when you know how to handle this stuff. The live is on, we're on YouTube, but if you go to my Telegram, you can go click the link to Zoom and join us on Zoom. All right. All right, but yeah, these are the kinds of questions you got to ask. All right, does that help a little bit?
Yes, it does. It does. Thanks, man.
Yeah, you're welcome. All right. Anything else? But yeah, if you do the writ of prohibition, if you do the appeal and the writ of prohibition, it should stop the garnishment right away. All right. Like, wait, hold on. There's an appeal here, but we're going to put everything on stay, right? And even do a motion to stay with the judge, so that way the judge will go and tell the whoever's garnishing to stop the garnishment.
Not to sound remedial or anything, but I've never done an appeal before.
Well, that's a whole other. You'll have to hit me up privately. We'll have to schedule a time or something to sort that stuff out. Okay.
Right. Yeah. Well, thanks,
Yeah.
man.
Hey, you're welcome. Yeah, because that stuff would be overwhelming. So, but I can help you with that.
Like, I don't mind the court stuff and all that. You know what I mean? It's just proper paperwork or process to get it started.
Yeah, no, I understand. Yeah, and you have to look up your state rules. Okay, so like you're in Illinois. So Illinois has all these other. Let's go here.
Yeah, I'm gonna go through all that. Hold on.
Yeah, just use this website, Justia.
Yep.
All right, because it has. Well, it's only doing the statutes. It should show everything else. Let's go back to here. If you go to, all right, so you have legal forms, law school. If you go other states, okay. What is going on? Okay, there you go. Practice area. Family law, divorce, traffic tickets, workers' comp, criminal law, consumer law. Oh, we don't want lawyers. I didn't realize that's what we're looking at. All right, but yeah, if you go through this website here, right, on your, you'll find eventually, because it has government, education, regulations, transportation. But what you got to find is one thing. You got to find the civil procedures in your state, the appeal procedures in your state. All right, and you have to find their rules of evidence, okay? And that's the stuff you're going to use to build your case. Rules of evidence, the civil procedures, and appellant procedures for your state. All right.
All right, cool. That sounds good.
Yeah,
All
that's
right, yeah.
a good place.
I'll let somebody else get a question in.
All right.
I'll
Anyone
come
else?
back with another question if no one else has one.
All right. What else is going on today, people?
Is
Nothing.
there a way to stop, like if someone had a credit card account closed, but has not yet had anything go to collections or anything, is there a way to stop that or change? I'm under the impression even if you send some money in, they can't bring it to collections, even if it's not a minimum amount, right?
Well, I mean, me personally, I want them to bring it to collections.
This is for someone who would not, because yeah, that would be easy. But this is for someone who would not have the time to go to court.
You don't have to go to court.
Okay.
No. Bringing it to collections doesn't mean it automatically goes to court. It means that they're going to try to spook you into giving them money because they're going to send it to court if you don't pay. And I go, this is great. I love these. These are my favorite. That's the best spot to be in. When something goes to collections, the debt collector writes to you and says, we're going to open up a court case unless you dispute this right now and, or pay us money. And then what I do is I go, you know what? I'm not going to dispute this. I do have a couple questions to ask you though. All right. First thing is, can you get someone with firsthand knowledge to certify and validate under oath that this is a valid debt? Number one. Number two, I do need to see the original copy of the letter of credit, what account the funds came out of and what account it went into. Can you provide that? Right? And you want to ask them, now, how much was loaned from the original creditor and what account did they get it from? And, just keep in mind, this has to be in adherence to 12 U.S. Code 83. Now you kind of got them like where the debt collector, you say, okay, and how much did you pay for this alleged debt? And how much are you hoping to make out of this alleged debt? And they're not going to answer that because they didn't buy yours. They bought a bundle of them, right? So they'd have to sit down and work out how much they paid for it, right? But the other thing is you can say, well, thank you very much, and just acknowledge the fact that they paid the debt. Say, well, thank you very much for buying the debt, the alleged debt. How much did you pay for it?
That was my thinking.
No. And I just ask them, bombard them with a bunch of questions like that they don't want to answer, and they'll just drop it. To me, that's always been the easiest way to handle those guys. I don't fight them. I just go, oh, I just want to make sure this is right. Can you give me some stuff so I can see that this is correct? And then they just write back loud, we're no longer pursuing this. Because they know awesome. if they bring it to court, they're like this guy's going to bring this up in discovery. Like, oh yeah, I need to see all this stuff in discovery. The only way they're going to get around that is with a judge who's going to be like an asshole, like a crooked criminal judge. And it's real simple. If you got a bad judge and the judge rules against you he says I am not granting your motion for discovery. Well, guess what? That's a mistrial right there. Dismiss, right? Brady rule violation, right? So I move for a mistrial. Brady rule violation. He goes, no, we're not doing it. Well, yeah, I'm asking for evidence and you're refusing and you're inhibiting my defense, the judges. So this is a mistrial. I mean, that's it, done. They could bring it up again later, but they'd have to get a different judge. They'd have to go through the whole process again, right? And the judge probably would grant the mistrial just because of the fact that he knows he broke the law. And if he were to just go against you on appeal, you'd win on appeal just by the fact that he wouldn't let you, he wouldn't grant you due process. So that's why the debt collections, I like those, right? That's the easiest one.
Awesome. Thank you, Joe.
Mm-hmm. Yeah, we've had tons of successes with the debt collectors. Every once in a while you get like these crazy, like somebody there, it's like usually a law firm, and then they'll just go anyway. They're like, well, we're going to sue you anyway. Now you're going to lose in court. And then what they'll do is they'll have a court case, never tell you about it. And then all of a sudden you come back with like a judgment against you. I'm like, what? I just write to the court and go, I was never informed of this. And then they drop the judgment because it's a void judgment because, I wasn't served. And that's, so even when they do that, if they're taking a risk because they know that if somebody knows anything about the court system, how it works, that you can service of process failed. So you void the judgment that way.
That happened to me.
They did that to you?
Yep. They didn't serve me properly. They tried to sue me. And when I found out about it, I turned around and I was like, what is this? You never informed me. And I got thrown out. Because like you said, service of process never happened.
Yep. Exactly. Yeah. I did that with a law firm because I wrote to the law firm. They sent me something and then they never spoke to me again. And then I got a letter saying that I lost in court. Now I wrote to the court. I was like, I didn't know there was a court case. How was I, if I was never served, how could we have had a court case? And they wrote back saying that the judgment was void. Right? Because they must have asked them. They said, "Can you prove that you served this guy?" And they had nothing. So that was that. And that was all handwritten letters too. I typed nothing on any of those. Yeah. All right. What else are we talking about today?
So my brother-in-law got a summons for a tax warrant saying that he didn't file his income tax in 2019.
This is from the IRS or state?
It's the state of Kansas.
Oh, I love that. Those are fun.
I told
Okay.
him he needed to call him and get the fax number, and then she needs to be able to prove that he filed federal income tax for the year.
He's a taxpayer.
Nope.
I would just write to them. I go, I mean, you have the Buck Act, okay? Everyone knows about the Buck Act now?
Remind me, please.
Uh-oh. You guys aren't watching my videos. I make all these wonderful videos on Rumble. No one watches them. All right, that's fine. So the Buck
No,
Act
I
was,
watch him, but remind me.
okay, the Buck Act is the act where they went and the Congress gave the state taxing authority to tax people, but it has to be on federal territory. The state's only taxing authority comes on federal territory or through businesses, like the sales tax. That's it. So they can't do a direct tax on your income either. Income. I'm saying income. Okay. But all he has to do is just ask them, is this voluntary? And they say no. You say, thank you very much. Now I have evidence that you're sanctioning involuntary servitude in the state of Kansas. And then you can send
Oh,
that to the
okay.
Attorney
Yeah.
General of the United States. Hey, these guys are sanctioning involuntary servitude. What do you think of that?
Okay, that's that. I like that better. Okay.
Right? But also you can use the Buck Act because they're you can say, show me the federal territory I was in or the federal zone I was in when this alleged taxable event occurred. And they got nothing on that because they'll have to tell you where the federal zone is. And they don't want to tell you that. They will not tell you that because once they put that on paper, that you can put out online, show everybody, look at all the federal zones that are secretly federal zones in the state. And they're going to show you the Capitol, federal zone. They're going to show you the post offices are federal zones. They're going to show you all the courthouses are federal zones, right? They don't want to do that.
Well, it's funny that you mentioned that because I went to our county and I asked them. I wanted to see the deed to the courthouse, and it went from a land grant to the commissioners, but the man that had the land grant, he wasn't the original land grant owner. So I was kind of confused of where the transaction was, and it didn't happen until 1899. So when did they usurp Kansas and make everybody start paying property tax?
I mean, for Kansas, I couldn't tell you.
Yeah,
Each
because
state's a little different. Kansas wasn't part of the Civil War or anything, as far as I know.
well, that Kurt Riggin that I sent you an email on, the tribal lawyer, he went to the National Archives and was able to dig up a bunch of the original constitutions that were hidden in a miscellaneous box. I sent you the YouTube in a video email.
I'll have to look for it.
And then so back in November when we purchased that land from an auction and we signed it without recourse, well, they're sending us the assessment saying that the house has increased in value from improvements to $1,600. Well, the house isn't even livable, and I slid their appraisal notice unsealed or completely sealed back across the table and said, we don't want a contract. Your contract was refused.
There you go. Yeah. See, like when it comes to like certain particular states like Kansas, I haven't done the research on that. I just know that the Reconstruction Acts, which I finished all the videos for the Reconstruction Acts. That's when they usurped all of the states and made them and federalized them. Was then. So I think all the states after that pretty much were probably federalized from the get go, whenever they became part of the union. So what they do is they bring them into the republic by making a new state, and then they federalize them by making them the state of after that. That's why I think is what's happening. Right? That's how I see it. But they're all military zones.
Yeah.
Right?
Yeah,
The
because of
zip
the zip
code. I
code.
mean, the
Yep.
zip codes prove
Yep.
it.
Yep. The zip code proves it. And then in 2000, when they started making everybody have the 911 addressing, they usurped even the rural routes.
Yeah. So the way I was thinking about bringing the rural route back is getting rid of the mailbox, right? You do the address update with the post office, and then you put the rural route from your thing on a box outside somewhere, and then they can start delivering to that rural route again. But you would know. We should talk about that outside of here.
Yeah. So some of the gatekeepers just won't budge. There are a few good people out there still, but they're few and far between.
What gatekeepers?
Postmasters.
Oh. Okay. But yeah, I think that would be a way to get that. That would be a way to do it. Is just get rid of the mailbox, get rid of the numbers, do a change of address, and then put the rural route there as the new address, and then put the box number out there, like the rural
Well,
route number.
the other thing I thought about was getting the longitude and latitude from my survey and put up all my signs, private property, and put up the fees for violating, and I'm calling it in joules, and the conversion of joules is your energy.
I would also make note of Article 1, Section 8, Clause 17, and put that on the sign, like, in accordance with Article 1, Section 8, Clause 17 of the Constitution of the United States of America. It specifically states that this is off limits and outside of the territorial jurisdiction of the United States or any entity of the United States, including any local or state officials.
Okay, thank you.
Yeah, so like that would be a good sign to put up. They probably look at that and go, "What the and then they would probably call somebody higher up. Hey, the sign says this, and they go, "Yeah, just go away, leave them alone." They won't bother them after that. They're like, kind of call them out from the get go. They're not gonna bother with you. But that's another thing is like when they're trying to contract with you like that, saying, "Oh, well, now you have to pay more money." I'm saying, "Well, I don't have a contract with you like that." Like you doing all these assessments on the value of the property. Did I ask for that assessment? Did I agree that I would pay more money because of your assessment? It's a very arbitrary thing. Do you have my consent? Where did I sign and consent to this? Right? They can't do anything without your consent. They need your consent.
It's assumed and presumed a social contract, and I went in and face to face told the appraisal man that no, we do not wish to contract. Contracts refused.
Yeah, contract refused. Well, you see, that's something I've been doing. I mean, you're in the trust community, so you saw. Did you see what we did with the registered mail and the contracts?
On which video?
Nope, I just talked about it. Okay,
I'll have to go. Is it one of the chats?
it's in the VIP section.
Okay, I'll go read because I've been kind of busy. I haven't checked the last couple days.
I mentioned it in a Rumble, like on Telegram live once, and I showed people how to do it. And everyone kind of overlooks it, but it's a very simple way to just negate those offers.
So
Okay?
which Rumble title are you referring
It was a
to?
live Telegram. Hold on, let me
Sure.
find it. Oh yeah, we could talk about the acquiring a car thing, but just keep in mind there's a lot of bad information about getting a car online. This one right here, see, I'm actually drawing it in the picture, right? Live Telegram Q&A, February 15th, 2024. Whoa, that was over a year ago.
Yeah.
And this is
A Valentine's present.
Yeah, look at that.
It's crazy how time flies like that.
Yeah. Yeah, if we go here, let's click on that. But yeah, I show you how to do it in here. See, registered mail number, refusal for cause without dishonor, UCC 3-501, UCC 2-2072C. That's it. And you just stick the summons right in there. I actually had a PDF version of this in the Telegram, but I don't know what happened to it. Someone deleted it or something. I don't know why people do that. I gotta stop letting people be able to delete stuff out of my Telegram. But yeah, that's it. That's how you do it. You know, that's tickets, summons, offers of contract from the local government. Oh, we saw you put up a fence. We're going to bill you. You didn't get a permit for that. So we're going to bill you $160. No, thanks. I'm not going to contract with you guys. You know, this is an easy way to do it. There's, so there's a guy I've been helping, right? He's actually a police officer. Okay, and he did that on some tickets from someone, not him personally, but someone else, right? I'm not gonna get into specifics. Someone else that he knows, he had them do that, and it worked 5 times. 5 different times it worked. So, and then the guy in the trust community, we did that one day. He was like, oh, I got this ticket, like $360 ticket. So I told him to do that. He went and did it, didn't show up. They sent him a letter after the court date, the supposed court date, offering him to come in on court to pay the ticket. And he's like, oh, I guess it didn't work. I'm like, it's just another offer. Do the same thing again with that. Just do it again. You know, it's third time's a charm, like that's the rule of 3 when it comes to dealing with these entities. If they come after you once, you do something. If they ignore it, you do the same thing again. Then they're going to do, if they ignore it a third time, you send it a third time, right? And then after that third time, they usually go, okay, fine, right? Because then they know that, they're just testing you. They're testing you, really. It's like some kind of like satanic ritual with the number 3 or something like that. I'm sure somebody either on TikTok or Telegram or YouTube knows what I'm talking about with the satanic 3 thing. So I'm probably Norman. He knows. Yeah. So that's one way to do it. Okay. Let's use that. The Tesla coil. Like the serpent. The coils actually do work. So I've done that with making like little generators.
The Oregon where you put the coils, the coil of copper and then the resin to.
No, I did it no, I was making like little generators. So I did like a copper coil, magnets, and then I put it to a bike, right? Like I hooked it up to a bike and I was able to like, charge like the little light on the bike and stuff like that.
Making electricity, huh?
Yeah, I was hoping I could power my house with that, but it didn't generate enough power. I was like, because I was going to do that, I was like, sweet, I'm going to like get all these car batteries, I'm going to charge them up with the bike, and then I'm going to run all the power through that, and then I'll just keep exercising to keep power, have free power. And it's a bit more effort than I realized then. This is like 20 years ago when I was doing that. I realized, it's going to take quite a bit of pedaling to charge that car battery. Live and learn, right? All right. So the proper way to acquire a car. So, there's a few ways to go about this, but one thing to understand is that when we're talking about like getting like my thing, I say the best thing to do is just buy it in cash, right? Buy a car from someone, get in cash, and then you don't have to deal with any of these hassles with these banks or anything like that. Just buy it from someone. But I know some people want to get new cars, they want to get nice cars, right? But now you have to look into the law of negotiable instruments. Right? You have to look into all that stuff, right? You have to look into these things. Like, let's go here, not here. the UCCs. Okay. And the first thing is we got to look at UCCs. Let's look at letters of credit, right? And we're going to look at first is the applicant, right? An issuer. What's an issuer? Oh, they don't let you click on the definitions anymore in the Uniform Commercial Code. And if we look at issuer here, let's go here. Maker means a person who signs or is identified in a note as a person undertaking to pay. So they consider you a maker of the promissory note or any kind of instrument, right? Well, note. Right. And then, so that's the maker. You're promising to pay. Issue of instrument. Issue means the first delivery of an instrument by the maker or drawer, whether to a holder or non-holder, for the purpose of giving rights on the instrument to any person. See? You're giving the rights over to someone. So what could you do to limit the rights that you're giving on an instrument?
Do the proper endorsement.
You could do a proper endorsement. That's one. Okay. Now let's look at these endorsements. Okay. Signature by representative. This is key. If a person acting purporting to act as a representative signs an instrument by either signing the name of the representative person or the name of the signer, the representative person is bound by the signature to the same extent that the representative person would be bound if the signature were on a simple contract. So they're saying if you're the representative for someone else and you sign for them, that person that's being represented is the one that has to pay. Okay. But there's things here. It says if the form of the signature shows unambiguously that the signature is made on behalf of the represented person who is identified in the instrument, the representative is not liable on the instrument. So what would that look like? Looks like this. By. See, it's already not blank, right? And now you're an authorized representative. But in what capacity are you acting as the authorized representative? Okay. So an authorized representative, but in what capacity? Some people go, oh, agent. But what kind of agent? There's all different types of agents. Okay. You have a beneficiary. You have a trustee. You have an executor. Right? You could say, well, I'm just the authorized, authorized representative. And you can do that. And you can sign it like that. All right. You could just do that. That would be okay.
So you can abbreviate AAR?
I would write authorized represent. I'm just abbreviating for the fact that I'm typing with a mouse. I'm writing this with a mouse. But yeah, I would just write, sign the name by, make sure you put by. If they have an X here or something, box in the X or color it in or something. Because they'll do that. They'll put you have the line and then they'll put an X here, right? So you want to box it in, take it off the page. Right? Color it in, all that stuff, get rid of it. And then sign like this. And look, if you got a check, go look at the check. I gotta do the puzzle piece for TikTok. If you look at look at a check, right? It says authorized signature, right? On the line on the front. Authorized signature is what it says. So what does that mean? It means it's not you, okay? You're not the entity. You're signing for the entity. But what you're doing is you're making yourself liable on those checks, right? Come to my Telegram channel and then find the Zoom link and join that way. All right. The YouTube is just my name. It's just Joe Lustica. But yeah, so when we're doing this here, we want to make sure that we're not creating any kind of liability on these things. So the buy, sign the name, authorized representative, get rid of their X, okay? But what else could we do? The signature is important, okay? The signature, the signer is not liable on the check if the signature is an authorized signature of the represented person. Okay? So it's kind of tricky because they do authorized signature, right? So you have to let them know that you're a representative of. And you could, I mean, there's no set way to do it. You got to be a little creative. Like think of how you would do it. Like what feels right to you, and that's the right way. All you're trying to do is show that you're the representative of that name, right? Like if we look here, let's go look up a check. We'll go to Google and we'll just go check. And then we're going to go images and let's look at a check. All right. John Q. Public. Come on. How to write a check. Thanks. Oh, what? I hate that. I think we can all see this pretty well though, right? Okay, so here we have that's the ens legis, okay? That's the bank. This is the bank's routing number, okay? This is like an intermediary. It's a pass-through, okay? This is your private account number between you and the bank. This number is connected to the Social Security account. Okay. What they did is they converted the Social Security account from whatever your original number was, right? To this new number. So what they're doing is they're overlapping your Social Security account with this number, okay? They're letting you fill the funds into this, baby account of this. Like this is the master file, okay? And this is like a minor account under this master file, right? The bank has a duty to be able to pass through from here. Now it's getting convoluted, right? All right, let's do that. All right, the bank has a duty to take this account is in the Federal Reserve, right? That's the Fed, okay? And they're using this number here to draw the funds out of this account to them. They then squish it over into here for you, and then you have access to this amount here. It's like a spendthrift type of thing. They're limiting your access to here, and they let you load this account up on your end, and then they insure it through this from your Social Security account. They pay for the insurance this way. Okay. Now, when you sign this thing, okay, right? Like you're going to sign here. We can't get any closer, but it says authorized signature right there, that line. Right? If someone has a check, go take a look and confirm it with me. Tell everyone what it says. But yeah, then you sign it. Like normally people just sign like this, right? They just sign. Ta-da, here you go. Well, why not write by? Authorized representative, right? Now what you're doing is you're transforming from being this person to just representing this person. And that's a person, that's a bank. Okay. And this thing follows the laws of the UCC. Check it out. Watch. I'll show you. This has everything to do, like this is perfectly in line with UCC 3-104, right? Negotiable instrument, right? It's payable to bearer to order, paid to the order of, is payable in demand or at a definite time. That's your memo section. Right? Does not state any other undertaking or instruction, right? By the person promising or ordering payment. I'll play some guitar when we're done, all right? I'll play at the end, I promise. And I think I will do Orion. I saw that earlier. I'll play Orion. All right. Promise or undertaking. Okay. So it's just saying does not state any other undertaking. So it doesn't say for deposit once you do a dance with your hands. Doesn't say that. So no other thing. So check draft.
Signing my next check like that, I'm gonna make them do a dance with their hands.
There you go. I love it. You must dance on your hands or else you can't take the check. All right. And order meets all the requirements. All right. Let's go issue of instrument. Okay. Issue to delivery, right? An unissued instrument. Okay. There's more to this. Unconditional order of promise, right? Instrument payable in foreign money, payable on demand or a definite time. Payable to bearer to order. You can see we're going to go through this, right? Identification of person to whom instrument is payable. That's who you right here. Paid to the order of who? Who are you paying? See, each one of these sections goes over another component of this check, right? Issue signature of the issuer is made by automated means. All right. Issue is payable to a trust or state, right? The instrument is payable to the trustee, the representative, or successor of either. So, all right. Place of payment. You see? What do you think they're doing here? Where's the place of payment here? Right there.
Joe, can you mute Dan?
Right there. That's your place of payment. It's not this bank. Because if it was the bank, why do they need your address? Oh, we need your address. We need your address. Why? Because they're taking it from that ens legis. That's the place of payment. It's not the bank. It's your person. Okay. An instrument is payable at the place of payment stated in the instrument. If no place of payment is stated, an instrument is payable at the address of the drawee or maker stated in the instrument. That's it right there. That's the maker.
Get it? Oh yeah, this.
If no address is stated, the place of payment is at the place of business of the drawee or maker. That would be the bank. Who's doing this now? Oh, here. Okay. All this background noise. All right. If a drawee or maker has more than one place of business, the place of payment is at any place of business the drawee maker chosen by the person entitled to enforce the instrument. If the drawee or maker has no place of business, the place of payment is the residence of the drawee or maker. That's why they have this on here. Okay. That way it's always this. Isn't that interesting?
So
Yes, very.
Yeah, what were you gonna say?
I was gonna say, so take a scenario where you go to a dealership, you find a car, you get a purchase order. The purchase order is signed by the dealership, and on that purchase order, it has VIN number, make, model, miles, and then the price for the car.
Mm-hmm.
If you sign that, authorized representative, you can take that instrument and convert it on a UCC1, do the 1AD, and then essentially go to a bank and assign them that security, right?
You can do that, yeah.
Does that work?
I have not done that. It's not a bad idea. The problem is, will the
Getting
bank
them.
take it?
Well, that's what I was gonna say. Is like, what happens if you assign it to a bank and then they don't do anything with it? You went through the Secretary of State. They did the UCC assignment, but then the bank decided that they weren't going to do anything.
Right. Well, that's the problem with the UCCs. So, like, you can file liens or do financing statements, stuff like that. But if the other party doesn't agree to it, then it's ineffective. So, what you have to do is you have to use notices. Notice them, notice them, notice them, and default. And if you notice them and they say nothing, you can default them, saying that, oh, I guess you guys agree, right? And then they'll probably, you got to give them 3 defaults, give them 3 chances. Just like, just like what we're doing, what we were talking about earlier, right? After the 3 defaults, it's confirmed that they agree if they don't reply back. And now you have an agreement. It's called nil decit, right? I had a whole thing about that. Judgment and nil decit. Where is that? There's my Corpus Juris Secundum books. Corpus Juris Secundum 49, I think it was. I found it.
So, all right. So going back to the quote proper way, since we all know that there's a gazillion methods, let's call them, for lack of better words, floating
Okay.
around, what would be a good remedy to use in this case?
In this case, I mean, it's hard to say because you're dealing with different states. Different states can react differently. Different banks can react differently. Different individuals, different people, they're all going to act a little differently about the same thing. The best thing to do is this: when you give them, my opinion, I think the best thing to do, sign it the way I was saying to sign it, right? Give it over to them. What you do is then you have to do, this is by the law. Like, this is when you're dealing with, oops, my thing got a little sticky. When you're doing something like this, right? This is probably one of the most important parts of this entire thing. Okay. And it's all about taxes. It comes down to taxes because what you're dealing with is you're dealing with securities, right? And debt instruments and income from discharge of indebtedness. IRS needs to know about this stuff. So you have to report these because otherwise it's a private contract between you and the company. Okay. Once you report it to the IRS, now they're involved in this process. Okay.
Is that where the 1099-A comes in?
You don't need a 1099-A. 1099-A is lender. All right, so all the 1099s just show you where money's flowing from one to another, right? Currency. You have guy A, and then you have guy B, okay, or person B, right? It's just showing you where money flowed to, okay? The different forms, A, B, C, D, or well, it's not D, but OID, right? Was a K, right? These just show you for what reason or how it flowed. A shows this lender to borrower. C shows borrower back to lender. Okay, so it shows the inverse. B shows that the money was flown, was made through or through brokerage transactions. OID shows debt instruments. Okay, so OID is a debt instrument. So if you're using a debt instrument, you use an OID to show that, yeah, B sent A the funds through a debt instrument. So now this A or the loan is canceled by the C. Okay. Does that make sense? So like the 1099s just show the flow of currency. The types of 1099 shows you in which capacity did it flow. All right. Now, when we look at, and this is why people go, "Oh, I did 1099-A, and they didn't send me the title of my car." I'm like, "Yeah, no, duh." Right? All you did was tell the IRS that money flew this way. Who is the lender? Who's the borrower? Right? They didn't pay you back, did they? Because a lot of people try to say that they're the lender, and they do this all wrong. By the way, I'll tell you flat out, everyone's doing this thing wrong. When you do the 1099-A, this is how everyone says to do it. They go, "Well, it's a 1099-A. You're the creditor, so you put your name here, right? Your name, right? You put the name of the company here, the bank over here. Well, guess what? What do you think people are putting in here with the name? They're putting their home address, right? 123 some road. Well, guess what? That's wrong. That's not the lender. That's not the lender's address. That could be the lender's name, yeah. That's not the lender's address. Where are they getting the funds from? When you give them the application and they go and take that and go draw the funds, where do they get those funds from?
Ben Lingus.
Trans Legis, but where is that? It's just the Federal Reserve Bank. You're giving them the wrong address. This is why no one ever produces anything out of this, because they're doing the wrong addresses.
That's fair. That's fair.
This is why I don't listen to these people. They say, "Oh, you gotta do this," and then when they start saying things like that, I'm like, "Well, I guess he's wrong."
Well, that's why, I came to you initially and I said, let's talk about it, because there's like 1,001 different quote remedies, but when you go and speak to somebody about the remedy, nobody has answers. So it's like, okay, well, if you're going to give me a half-assed process, then I don't need to.
Because they don't. Well, one thing is this: most people just listen to other people and try to piece together what other people are saying.
Yep.
They don't go and read these things. Like, I'm going to show you something in here. This is very important. This is super, super important. This is how I've gotten. This is why I get remedy.
Because you read.
Because I read, and then I go and I read things, and then I go say, okay, this is how it goes. This is how this works, right? So look, discharge of indebtedness income not taken into account in determining whether or not okay. Look, 10, indebtedness satisfied by issuance of debt instrument. Someone say that out loud, so it's not just me saying that.
Indebtedness satisfied by issuance of debt instrument, aka negotiable instrument.
Right. And look, they're going to define debt instrument here. Debt instrument means a bond, a debenture, which is an unsecured loan. That's a credit card agreement. Note. What do they mean by note? A promise to pay? A promissory note? A Federal Reserve note?
Bill of exchange?
No, that's not a bill of exchange. But a note, because a bill of exchange is an order to pay, or this is a promise to pay, right? A certificate or any other instrument, like a certificate, like a W-4, withholding certificate. That's what a W-4 is, right? Look, W-4. W-4. Employees withholding certificate. What are you doing? You're paying the IRS. This is a debt instrument saying you owe them money, so they're going to take it. You don't realize what they're looking at, right? Certificate or any other instrument or contractual arrangement constituting indebtedness. Now that right there tells you everything. Anything that I could write on a piece of paper, DNS office owes me $1,000, right? Now we got a contractual arrangement. I just got to get you to sign it. The second you sign it, boom, we're good to go. Right? You sign it. Now I have a debt instrument.
So with that logic, if a purchase order is signed by the dealership and an individual, wouldn't that make it a contractual obligation?
Yes. But what is it? It's a debt instrument. Well, what? Can you satisfy indebtedness by issuing a debt instrument? Yeah.
No.
They're telling you can. It says right here, for purposes of determining income of a debtor from discharge of indebtedness, if a debtor issues There's the issuer. The debtor is the issuer. Issues a debt instrument in satisfaction of indebtedness. Such debtor shall be treated as having satisfied the indebtedness with an amount of money equal to the issue price of such debt instrument. So what have you done? You've just settled the matter right from the get-go. And everything they're doing from that point on is breach of contract. In law, it's called breach of contract.
So if the vehicle that we're talking about, let's say in this example, right? We have the 1099A, and not the A, I'm sorry. We have the purchase order, duly signed. You do the UCC one, you do the AD, you assign it to the bank. The bank decides not to play game or not to go through the transaction. Then they are actually in breach of contract. So now we have to go to court and sue them for breach of contract.
You don't have to do that.
Really? Okay.
Yeah. Well, how do you report to the IRS when you use a debt instrument for a debt?
I don't know.
Well, look, what is this? This is the flow of money, right? That's what it is. It shows you that here, let's call D the debtor, and we're going to call B the bank, right? If you issue them a debt instrument, right? That means that you're good. You paid it off now, right? That's a flow of money.
So
What are the 1099s?
So you would do a negotiable instrument and a 1099. That would suffice, right?
Someone got it right in the contracting roofing. Got it right.
Would you have to do an OID?
Yes, that's it. It's a 1099 OID. Because look, 1099 OID. All right. Right. Look at what it says. File form 1099 OID. If the original issue discount. So people don't understand what original issue discount is, so they kind of overlook all this stuff. Original issue discount is the stated interest on a debt instrument. Okay. And let's see here. Let's look at the instructions. So we're going to look at the instructions, and we're going to look at the definition of OID. Where is it? Where is it? No definitions? Come on. Definitions.
So wait. So let's say in the same example, you would do you would get the financing quote unquote from the bank and then just OID the bank for the initial issue. Let's say it's 50,000.
Yeah. Now look. Stop. OID is the excess of an obligation stated redemption price at maturity over its issue price. Remember, you're only discharging the issue price of the debt instrument. But if it's on day one, it's a done deal. Right? In the case of a taxable obligation, a discount of less than 1/4 of 1% of the stated redemption price of maturity multiplied by the number of years from the date of issuance maturity is considered to be 0. Okay, so that's it. It's the excess of an obligation stated redemption price at maturity. So like if you issue this instrument for like, let's say 50,000 and it has, let's say the interest is going to add up to another like 10,000 by the end of 10 years, let's just say, right? So the OID would be $10,000. This is where things get tricky because you have to know math to do these things correctly. Otherwise it won't work if you do it wrong. This is why people don't teach this stuff, because they don't know math. Some people know math, but some of these people can't teach it because they themselves don't understand math well enough. So they can't actually break down the reporting requirements of an OID.
They can't also read either, so there's that.
They can't read. People can't read, that's for sure. They can't read. People don't even know that. I'm telling you, because I was a middle school teacher, they'd bring kids to me and they go, this kid has a hard time in math. And he goes, I hate math. Math sucks. I go, what's math mean? He's like, math? I don't know. They always say it just like that. They kind of, I don't know. They don't even know what the word means. If you don't know what the word means, how do you know what subject you're talking about?
You know you don't like it, right?
Poor kid. But here's where it is. See, original issue discount. Well, what's the redemption price? Right? So if the bond, if it's like a bond and at the redemption price it's 60,000, well, there you go. Right? Well, it's the 10,000 actually is what it is. Because that's the OID. Right? periodic interest, whatever that is. Thank you, Donald, for contributing. He's putting ovals in here for us. I don't care. I know you're probably like, I didn't mean to. Original issue discount on U.S. Treasury obligations, market discount. So this is the difference. So you have your 10,000 is the redemption or the interest payments. The market discount would be the 10,000, right? Because they're getting it at a discount rate, 50,000. Okay, acquisition premium, that's the 50,000. Okay. If there's an early withdrawal penalty, sometimes there is, but in what we're dealing with, probably not. This more applies to bonds. Okay, the bond premium,
The
tax exempt.
description would be what? The PO?
Yeah, purchase order. Okay, but I'm gonna have to. Oh, I got to get out of here soon. I got to catch a bus. I'm going back into the city again. It's you don't have to private message me, just ask. It's 26 US code 108. All right. Yes, I'll do Metallica. But
Thanks, Joe.
yeah. But yeah, so by the way, just so you guys know, we're leaking into those more of the private side of things, which we can't discuss too much on these platforms. Like, it's fun. I love it. Don't get me wrong. I would love to, but I know what's going to happen if I continue sharing this stuff on the other end of things. All right. So, but I do in my trust community. Anyone here from the trust community?
Love it.
Okay.
Yes,
Yeah.
it's awesome.
So yeah, you guys are welcome to join the trust community where we're free to talk about these things. Okay. And, everything's under NDA. We keep everything private, like including unless you say like, I'm here, I'm part of it. All right.
I'm gonna get with the other group, and then we'll probably end up doing a consult with you.
All right, that's fine. But yeah, that's one thing that we're doing is that we're doing that stuff in there, and
How do we get in your
gonna-
community?
I have a link. I'm gonna look for it right now. Hold on. Let's see.
All right.
It's breedivine.com actually. I know it sounds funny because you're like, huh? Why is it Bree? But it's because Bree sets the whole thing up. She does all that back end stuff, so I don't have to. All right, but go to breedivine.com. I'm gonna drop it in the chat here. I'm gonna put it up in YouTube for everybody on YouTube. Here. Okay. I never received a. Oh, OSO. No, it's fine. You email me. I'll sort that out with you about the not getting the other classes. Okay. I didn't see that until now. I wasn't looking on YouTube at all. 1099. So that's the link for the trust community. It's in there and there. And hey, Livy. I'm gonna see if I can share it in. Can I share it in? TikTok doesn't like when I share this link. It actually like blocks it a lot of times, but I'm gonna try anyway. All right, let's try that. That should be good. Did it work? You guys see it? But yeah, pin. I pinned it. Oh, it wouldn't let me pin it in TikTok. You see? You see the kind of fraud? See? Bree Divine, like Divine, right? Divine. BreeDivine.com, and then it says a link for the trust community. That's my community. It's in there. All right. Oh shoot. Let me try it again here. All right, there's the link for that. It's in there. It's on YouTube for everybody on YouTube as well. It's a boss community. Thank you. I appreciate that. Bree Divine. Thank you, Living. That's so smart. See, I wouldn't have thought of that. All right. I got a 7-string guitar today. But yeah, why don't we do this song? Any other questions? Quick questions before I head out.
Yeah, I got one.
Yeah.
When you were doing that OID and you said that people are filling in their own address, and then you said that you got to fill in like, would you say the Fed or the Treasury? Would that be 111 Constitution Avenue Northwest?
No, it's where the Social Security account is actually located. So
And
what
that
you have to do is you have to look on the back of your Social Security card and find the red letter,
okay,
and then that coincides with the Federal Reserve Bank that your account is at, and then you go look up their address.
okay, thank you.
But that's for the A's when you're doing that side of it. But when you do that stuff, that's more of a letter of credit, because when they're doing the notes and the promissory notes, they're calling themselves the lender and you the borrower. So the whole thing flips over the other way. So you have to make sure when you're doing those A's like that, that it's a letter of credit, because you're the one that gave them that credit, all right, for them to access the Social Security account in the first place through the application. That's how that A is supposed to work. So that's not your home address, it's the Federal Reserve one, okay? For educational purposes only.
Thanks again.
What is going on with this thing? No. There we go. Mine doesn't have one. Do you have to order a new one then? That's the only way you're gonna find out. All right, what are we doing? Oh wait. Oh, the 7-6 threw me off. Yeah, something like that. Next time I'll do the whole thing. All right. That's going to be pretty much it for me today. Guys, I'd love to see you in the community. That way we can have these in-depth conversations. They're less restrictive in there because there's no censorship inside the community. Number one. Number two, it's all private. For Whom the Bell Tolls, we'll have to do that. Well, we got a lot of cool songs we're going to have to do. I get it. All right, here's what we'll do. We'll do the entire Ride the Lightning album and the entire Master of Puppets album. How's that sound? From beginning to end. All right. Yeah, I think that's about it. Any other quick questions before I head out? Oh, yeah, you're welcome. Well, thanks, everybody. It's been great hanging out with you, and I'll see everyone later.